North Carolina gives landlords broad freedom to set and raise rent, and the state's minimal regulatory approach makes it one of the simpler frameworks to navigate. The governing law is found in North Carolina General Statutes Chapter 42, which covers landlord and tenant relations, and while it establishes important procedural requirements for the landlord-tenant relationship, it places no restrictions on the amount a landlord can charge. North Carolina does not have rent control or rent stabilization. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain any form of government approval before raising rent. North Carolina's political and regulatory environment strongly favors property rights and market-based pricing, and rent control has never gained meaningful legislative traction in the state. North Carolina has enacted a preemption statute that specifically prohibits local governments from imposing rent control. Under Section 4214.1, no county or municipality in North Carolina can enact any ordinance or resolution that would control the amount of rent charged for private residential property. This means Charlotte, Raleigh, Durham, Greensboro, Asheville, and every other North Carolina municipality are legally barred from implementing rent caps, regardless of local political sentiment around housing affordability. This preemption is particularly significant given the rapid growth that many North Carolina cities have experienced. Charlotte and the Research Triangle region have seen explosive population growth and substantial rent increases, creating intense political discussions around affordability. But the preemption statute ensures that the state's market-based framework remains uniform across all jurisdictions. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. North Carolina requires at least 7 days' notice before the end of the rental period for changes to a month-to-month tenancy. That's right, just 7 days. This is one of the shortest rent increase notice periods in the entire country, matching the state's remarkably short no-cause termination notice period that we discussed in our North Carolina lease termination video. However, and this is important, the lease can require a longer notice period, and many North Carolina leases do specify 30 days notice for rent changes. Always check what the lease says before relying on the 7-day statutory minimum. If the lease requires 30 days notice and you only provide 7, you haven't complied with the lease terms, which can create complications. So if rent is due on the 1st and you want the increase to take effect on May 1st, and your lease only requires the statutory minimum, you'd need to deliver written notice by April 23rd at the latest. But if the lease requires 30 days, you'd need to deliver by April 1st. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. North Carolina doesn't prescribe a specific statutory form, but a clear written notice delivered by a documented method is always recommended. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing mid-term increases. Escalation clauses, CPI adjustments, and provisions tied to property tax changes are all enforceable in North Carolina as long as both parties agreed to the terms when the lease was signed. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent amount as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent well in advance. North Carolina doesn't prescribe a specific notice period for rent increases at renewal, since the increase is part of a new contractual arrangement, but providing adequate notice is good practice. If the tenant doesn't agree to the new rate, the lease expires at the end of its term. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the applicable notice period for future changes. For year-to-year leases, the notice period for changes is 1 month before the end of the annual term. For week-to-week tenancies, the notice period is 2 days before the end of the weekly term, consistent with the state's short notice standards. Now let's cover the restrictions that apply, even without rent control. Rent increases cannot be retaliatory. North Carolina has a specific anti-retaliation provision under Section 42 to 37.1 that prohibits landlords from taking adverse action, including raising rent, in retaliation for a tenant exercising certain legal rights. Protected activities include making a good faith complaint about a code violation to a government agency, making a good faith complaint to the landlord about conditions that violate applicable building or housing codes, exercising rights under the Residential Rental Agreements Act, and participating in a tenants organization. North Carolina's anti-retaliation statute provides that if a landlord takes retaliatory action, the tenant can raise retaliation as a defense in any subsequent proceeding. The statute creates a rebuttable presumption of retaliation if adverse action is taken within 12 months of the tenant's protected activity. 12 months is one of the longer presumption periods in the country and gives North Carolina tenants substantial protection. However, the presumption can be rebutted if the landlord demonstrates that the increase was motivated by legitimate business factors. If the landlord can show that the increase was planned independently, was consistent with increases applied to other comparable units, and was justified by market conditions or operating cost changes, the presumption can be overcome. The consequences of a retaliatory rent increase can include the invalidation of the increase, liability for damages, and attorney's fees. A finding of retaliation also damages the landlord's credibility in any related proceedings. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the North Carolina Fair Housing Act, found in North Carolina General Statutes Chapter 41A, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The North Carolina Human Relations Commission investigates fair housing complaints and can take enforcement action. A discriminatory rent increase doesn't require direct evidence of intent. A pattern of disparate treatment is sufficient to support a complaint. Raising rent for families with children while keeping rates stable for childless tenants in comparable units. Implementing larger increases for tenants of a particular racial or ethnic background. Any such pattern can result in a fair housing investigation and potential liability. The best protection is consistency and documentation. Apply the same criteria for increases across all comparable units. Document the business justification, and keep records showing uniform treatment regardless of tenant characteristics. From a practical standpoint, North Carolina's rental market is one of the fastest growing in the Southeast, and the state offers a wide range of market conditions across its different regions. Charlotte has emerged as one of the strongest rental markets in the country. The city's growth has been driven by the financial services sector. Charlotte is the second largest banking center in the United States, along with healthcare, technology, energy, and corporate headquarters relocations. The Charlotte metro area, including surrounding communities like Concord, Huntersville, Matthews, and Mooresville, has seen significant rent increases over the past several years. Landlords in Charlotte generally have strong pricing power, particularly in desirable neighborhoods like South End, Noda, Plaza Midwood, and Uptown adjacent areas. The Research Triangle, Raleigh, Durham, and Chapel Hill, is another powerhouse rental market driven by technology, biotech, pharmaceuticals, and 3 major research universities. The Triangle has attracted enormous corporate investment, including the Apple campus and numerous other technology employers. Rents have increased substantially, and the market supports regular annual increases. Each Triangle city has its own personality. Raleigh is the largest and most commercially diverse. Durham has a revitalized downtown with strong creative economy appeal, and Chapel Hill's market is heavily influenced by UNC. Greensboro, Winston-Salem, and the Triad region have more moderate rental markets, but have seen growth driven by manufacturing, healthcare, and logistics. The region offers affordability relative to Charlotte and the Triangle, which has attracted some population spillover. Asheville has one of the tightest rental markets in North Carolina, driven by tourism, the arts and music scene, healthcare, and a desirable mountain lifestyle. Despite being a relatively small city, Asheville's rents are disproportionately high due to limited supply and strong demand. Landlords in Asheville have significant pricing power but should be aware that the city's tenant advocacy community is active and vocal, even though the state's preemption statute prevents local rent control. Wilmington and the coastal communities have rental markets influenced by tourism, the military, Camp Lejeune, and Marine Corps Air Station Cherry Point. and the University of North Carolina, Wilmington. Seasonal demand fluctuations affect coastal markets, and landlords should understand the difference between year-round and seasonal pricing dynamics. The military presence across North Carolina, Fort Liberty, Camp Lejeune, Marine Corps Air Station Cherry Point, Seymour Johnson Air Force Base, and others, creates substantial rental demand in several communities. Military tenants' housing budgets are tied to BAH rates, and landlords near military installations should monitor annual BAH adjustments when planning rent increases. Pricing above the BAH rate can make units less competitive for service members. One best practice for North Carolina landlords, even though the state only requires 7 days notice for month-to-month tenancies, always include a longer notice requirement in your lease. 30 days is the standard that most tenants expect and that most professional property managers use. The 7-day statutory minimum may be legally sufficient, but it's so short that it can catch tenants off guard and damage the relationship. A 30-day lease provision is better for business even though it's not legally required. Another best practice: in high-growth markets like Charlotte and the Triangle, conduct regular market analyses to ensure your rents are keeping pace. In rapidly appreciating markets, landlords who skip annual increases for several years and then try to implement a large catch-up increase often face more resistance and higher turnover than landlords who implement smaller, more frequent adjustments. Keeping your rent close to market rate through regular, moderate increases is the most effective long-term pricing strategy. For landlords in college towns, including Chapel Hill, Greenville, Boone, and Wilmington, understanding the student rental market cycle is important. Student leases typically turn over annually, giving landlords a natural opportunity to adjust rent. Competition among student housing providers can be intense, so pricing must reflect the local market for student-appropriate housing. North Carolina requires landlords to hold security deposits in a trust account at a licensed North Carolina banking institution, or furnish a bond from a licensed insurance company. The deposit must be returned within 30 days of the tenant vacating. While these rules don't directly regulate rent increases, landlords should be aware that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For North Carolina landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority compares the proposed rent to comparable unassisted units and evaluates whether the increase is reasonable. Submit requests well in advance of the desired effective date. For the complete guide to North Carolina rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.